All rise. First District Court of Appeals now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We have one case on the docket today. Teresa Moon Valeno versus Florida Association of County Clerks et al. Is the appellant ready to proceed? You may.
Good afternoon. I'm Adam Richardson on behalf of the plaintiff's appellants. I'd like to reserve 5 minutes of time for rebuttal. Before I begin argument and questions, I do want to make two corrections
Well, first let's start the clock.
Oh, of course. Thank you.
Madam Clerk, thank you.
I just wanted to make two corrections. So we cited two older cases in our initial brief. The first was Cummings versus Missouri, which is a U.S. Supreme Court case. And apparently they couple the attorney's arguments with the opinions of the court and justices in Westlaw without making, I don't think, clear delineation. So what we quoted was from attorney argument, but at the same time, in the opinion of the court agreed with that argument and said basically the same thing, which is you can't do indirectly what you're prohibited
Well,
by.
speaking of the Supreme Court, why don't you talk about the Supreme Court's opinion in the May case, 1952?
Right, the declaratory judgment. Right. So that, of course, has actually, Judge Ray said in the McNeil case, imposes some extra statutory requirements that are, I guess you could consider prudential in protecting the constitutional authority of the courts so that they don't wind up
Rendering advisory opinions.
Exactly, sir. So I think that we do satisfy those requirements. I don't think that we're asking for an advisory opinion. And
How so?
Because in our complaint in count 3, particularly, I think it's in subparagraph D or F in there on page 41 and 42, which is where we list our prayers for relief. And in one of those subparagraphs, we ask for not just a declaratory judgment on what the statute means and what the clerks can and can't do, but also for the return of any money that was collected in violation of that statute to our clients and then other class members. So,
but wouldn't that basically be a backdoor way of trying to accomplish what is not allowed under the statute, which is a private right of action?
I have two responses for that. And the first is that the Chapter 86, the Declaratory Judgment Act, is fairly broad. Again, as you noted in McNeil, but also at the same time noting that it's not limitless. There are those prudential considerations. But the statute does allow us to, and this is 86011 subsection 2.
The text of the statute allows it.
Yes.
I think the text of the statute can allow a declaratory judgment action to be sought to ascertain legal rights, whereas here it appears that the appellees are in blatant violation of state law by charging excessive credit card fees to citizens to use their credit cards to pay their bills. But the statute doesn't, the statute's been interpreted, if you will, bouncing against the walls of Article 5, requiring that there be some justiciable controversy. And you didn't seem in your initial brief to argue for a private cause of action for that refund. What's the basis for the refund that you're demanding?
The basis for the refund would be basically a follow-on, or in the words of the statute 86011, subsequent or supplemental relief from a declaratory or a declaration about the application of the statute.
So you're entitled to a declaratory judgment that the clerks are in violation of the prohibition on receiving a profit from credit card charges, and therefore are you going to file a supplemental action, or how does that work?
I don't see us filing a supplemental action because we have already included that claim or that request for a return of. So
the circuit judge can grant you a refund after it grants you, speaking hypothetically, after it grants you a declaratory judgment, it can grant you a refund pursuant to that judgment?
That's our argument and my interpretation of the plain language of the statute, even with May versus Holly and the limitations it places on the Declaratory Judgment Act.
But I guess going back to my original question, so I think you would agree that there's no private right of action that exists under the statute 215.322 to allow for the recoupment of any excess fees, correct?
Yes.
And so is it appropriate then to use the DJA as basically a backdoor way to accomplish what the legislature has not delineated as a remedy under 215.322?
No, and that's because we believe that we have satisfied those May versus Holly requirements. So I understand like there is a concern of using it as a backdoor and indirect manner to be able to get the recoupment of the excess money that was paid. But at the same time, we do have the Declaratory Judgment Act that allows us to make these kinds of claims so long as the requirements are met. And the requirements here are met. We have the antagonistic right. We have antagonistic interests. We're not asking merely for an advisory opinion. And because of that kind of consequence, the recoupment of the fees, we believe that this is properly sought as a declaratory judgment, even if there's no implied private right of action.
Well,
under the
why
statute.
then is it necessary to have a body of case law and express right of actions and implied right of actions when you can just use the DJA as a mechanism to seek damages under any statute?
I think you have to reconcile those two lines of cases. So we have the first line of cases that, and even under the language of the DJA, saying that this is quite liberal and this is a cause of action that allows us to seek certain things. And then you have, on the other hand, the line of cases starting with the, I think, Murphy, right, that says, absent indications of legislative intent, exactly what you were saying, right? Mm-hmm. And so I think you have to reconcile them, and I understand this may be angels dancing on the head of the pin, but right, we're not saying count 3, you are violating this statute that's our cause of action. You have a duty to do something. We're saying you violated that by charging our clients an unlawful fee. Give us the money back. This is different. We're proceeding under the form of the Declaratory Judgment Act, meeting the requirements. And I think in order to give full effect to the Declaratory Judgment Act, you have to allow for certain kinds of actions like this one, even if they wouldn't be separately actionable.
Read us the text of the supplemental relief portion of the statute on which you rely.
Sorry, sir?
Read us the text of the supplemental relief provisions upon which you rely for this argument.
Yes. So, again, it's Section 86011, subsection 2. It's the last sentence. Any person seeking a declaratory judgment may also demand additional, alternative, coercive, subsequent, or supplemental relief in the same action. And so what we're relying on in the language, that language, is subsequent or supplemental relief. So
would it be, so could a circuit judge, in this case, for example, let's say, which this circuit judge did, say that the clerks were receiving a profit and violate, essentially, I mean, obviously that violates the state statute. So the clerks are receiving a profit of millions of dollars a year from excessive credit card fees. Are you going to be able to use that supplemental relief provision to obtain damages of millions of dollars for a class action suit?
That's our argument, and that's our reading of the statute.
So
exactly.
I mean, I think, just following up on my colleague's question then, so even though there's no private cause of action in the statute, which in your brief you tend to argue that maybe there is, but we won't go there. But despite that, the declaratory judgment action alone, by granting you broad language to ascertain your status and construe this statute, also by its plain language allows for collection of damages.
Yes, that is our argument. I want to be clear, that's exactly our argument. That is, under that language, we are first allowed to seek a declaration of rights and status. And
Let's talk about the clerk's argument that because they formed a private corporation that charged these excessive fees, they themselves as a state entity are not violating the statute.
Yes. So our argument, of course, is based on that principle that you can't do indirectly what you are prohibited from doing directly. We cited, I think, basically when I was preparing, I kind of boiled it down. So they're controlled, they formed an association that's more like a trade association, like many other trade associations. Then they turn around and form that for-profit Fax Services Group Corporation. They control it. The clerks themselves control it through Fax Services and then through through the association and then through Fax Services. I think the evidence is fairly overwhelming in the record that they do exert a lot of control over it.
Well, in fact, they receive dividends every year, right?
I don't think that's the only evidence of control. For example,
No, I'm just asking, did you establish below that the clerks themselves, the state entity, the governmental actors, receive dividends from the credit card fees?
no, there's no evidence that the clerks themselves as individuals were receiving like dollars, money.
Who receives the millions of dollars in dividends
The association.
of county clerks?
Yes, of all the county clerks, including one comptroller, the only members, as far as the record indicates, are the clerks themselves.
But the association distributes the dividends to the clerks, correct?
No, it doesn't distribute
Well,
dividends.
it sponsors 3 educational conferences a year, and also for every educational hour, that impacts the clerk's salaries to an advantageous degree.
Yes, and not just clerks. So I want to be clear about that. I guess there's a statute that allows a number of different officials, if they meet certain continuing education requirements, to do that. Clerks just happen to be one of them. But yes, that is what the record establishes. But there are also other benefits. So even though the clerks themselves are not being passed along these dividends from Fax Services to the association right to themselves, they are still receiving the benefits of those dividends. The association makes very little money in dues. I don't think it's even $150,000. But they are able to give their members a lot of different services. They're able to pay for things that are traditional association activities that they wouldn't be able to pay for without those dividend distributions. For example, public affairs, communications, lobbying, all of those are, together in hundreds of thousands of dollars. So even though, Judge Thomas, they're not receiving cash from the dividends through the association, they still receive significant benefits because of what the association is allowed to do, has the opportunity to do.
And according to your brief, at least, the fee that is being charged by the corporation that the clerks formed is 3.5%, right?
Yes, for a number of different services, but not all
Right.
of them.
Let's take the example of a citizen gets a speeding ticket.
Yes.
Let's say they get a $300 speeding ticket. They really pushed it to the maximum. They receive a $300 speeding ticket that they pay for through the clerk's offices. They pay a 3.5% credit card fee. The industry standard, according to your brief, is 2.5%, correct?
There's evidence that is the industry standard from the president of SMI, which is another corporation that was.
But this fee has generated revenues for the association. Is that correct?
Certainly, yes, but I think there's a little bit of a distinction that in preparing for oral argument I kind of came across. So yes, they're making a profit on that because they're charging something in excess of their costs. If they were a truly private corporation, which of course we're saying they're not, then the industry standard could be 2.5% or higher because the private corporation would not be subject to the statute and therefore allowed to make a profit and charge that higher fee. It's just that in this circumstance, yes, I think there is evidence that the industry standard is 2.5%, but also because of the statute, they're not allowed to charge more than the costs, which probably maybe is around 2.5%. But in any event, of course, it's undisputed that they are making a profit off of the convenience fee.
Let me ask you this. In your reply brief, you seem to make an argument, although you don't expound on it as much as I would have liked, but you seem to make a distinction between whether this statute 215.322 is regulatory or not, as if that label would somehow impact the elements or requirements for declaratory judgment. Can you expound on that more?
Yes, I actually think that goes to one of the questions your colleagues asked. So we don't argue that there is an implied private cause of action, and I think that's really relevant to that kind of a question, because if it's a purely regulatory statute, then you can't have that private cause of action. We were responding to what was in the answer brief, but I don't think that really impacts what our declaratory judgment argument is, except I think that a declaratory judgment action is particularly compelling here because, unlike a lot of regulatory statutes, there are no enforcement mechanisms that I could find in the statute. For example, if you're looking at the statute and the structure of the statute, it deals with state agencies and the judicial branch, and there are a lot of paragraphs in the statute that deal with that. But subsection 5, which is what we're dealing with here, that applies to units of local government, doesn't have some of the other language in other parts of the statute directing the CFO to adopt rules and regulations that perhaps then would allow enforcement in cases where, like here, they're not following the terms of the statute. So it's hard to see any other way to vindicate or to force compliance with the terms of the statute against units of local government like the clerks if there's no declaratory judgment.
Let me ask you to go back to your argument. You and the circuit court apparently agreed that there's no question that the clerks association, if you will, are making a profit on the credit card fees. You almost seem to backtrack a little bit on that. You said, well, the industry standard's 2.5%, but there's no question they're making a profit because the corporation pays dividends to the association, correct?
Yes.
The association then provides services and benefits to the clerk, such as I recall, $500,000 for public affairs.
Yes.
Your argument is that $500,000 is profit from the credit card processing fee. Is that
It's
correct?
funded at least in part by profit from the communities because the FAC and I think the services group have other sources of
So
revenue.
your argument is essentially that if the corporation of the clerks were obeying the law, then there would be no dividends available to the association. In other words, that corporation could charge 2.5%, 2.75%, 3%, whatever that corporation was required to maintain as a profit margin for its survivability, but that's not allowed under the statute if it produces excess revenues, correct?
Yes, I think that's a fair summary of our argument. There is, though, that evidence in the record from the testimony of, forgot the name of the guy, but he's the president of SMI, his depositions in the record, where he said that the industry standard is around 2.5%, although I think there's evidence in the record that can go higher or lower than that. But because of the terms of the statute, yes, here, regardless of what the industry standard is, they're not allowed to earn a profit off of that. And that is the problem.
So your argument is essentially that the clerks could subcontract out to Visa or whomever to charge a fee for the citizen's $300 parking ticket or speeding ticket to process that bill, but they cannot make a penny under the statute in profit. Is that right?
Yes, sir.
All right.
And that's really the problem here, is that, yes, they could hire legitimately private payment processors, and that payment processor would be entitled to make a profit, and then the clerks could pass that along to consumers. It just, here we have a captured, wholly owned subsidiary of the clerks and their association.
And if they subcontracted that out to Visa or MasterCard, the fee might be 4%, if that's what Visa and MasterCard demanded as part of their contract.
Market realities, yes, sir.
Well, Judge Thomas, you mind if I ask a follow-up
Please do,
question?
please
Because
do.
I don't want to get into your rebuttal time too much, and perhaps we'll get some
Please.
a gracious extension. I just want to make sure we're looking at the same subparagraph of the statute, and I have been looking at sub 5, which talks about a local government, including any clerk of court.
Yes.
Is that right? And as opposed to an earlier provision in the statute that talks about state agencies or the judicial branch.
Yes.
And under sub 5, the amount of recovery is limited to the service fee necessary, the amount sufficient to pay the service fee charges by the financial institution, vending service company, or the credit card company. So where is there room for profit in any measure under that language to whatever company the clerk or the local body decided to delegate that function to?
And I'll grant you an additional 5 minutes to both sides.
Thank you. I think the concern of the statute here is that the units of local government themselves shouldn't be able to make a profit off of the services they provide. So that's why they're not allowed to do it here. But I think the distinction with private companies is that they are. So if a private company were charging this and they were making a profit and the clerks passed along that whole thing, 3.5%, 4%, the clerks themselves are still not making a profit. They don't keep any of that money. And so under that circumstance, it would be permissible. Again, it's just that here, the clerks and their association have a wholly owned subsidiary that does exactly what they're not supposed to do. And I know I'm well into my time, so thank you.
Thank you.
May it please the court. I'm Barry Richard, and I represent the appellees. Before I get into the substance of the arguments, I'd like to clarify one fact. Counsel refers to an affidavit that was filed in the court below with the conclusory statement that the clerk's 3.5% is higher than the industry average. I don't know what they mean by industry average, but I do know what all of the clerks who use non-FACC processors are charged. And there are 16 clerks in Florida who do not use the FACC. They use other private processors. Not one of them charges less than 3.5% for online credit card charges. Half of them charge 5%, and Palm Beach County for telephone credit card charges between 7 and 12%.
Mr. Richard, could you pull the microphone a little closer, if possible? Thank you.
Yes, sure.
Thank you.
Sorry, Your Honor.
That's all right.
So the point is, what the clerks charge is actually the lowest amount charged by any of the private companies that are serving the Florida clerks.
But I think the question is, does the association receive a dividend from the corporation that is based in part on revenues from the credit card fees?
Yes, they receive money, and they use that money.
Isn't that a violation of the statute?
No.
Why not?
Well, the statute, Your Honor, does three things. It encourages, as we know, agencies to use credit cards. It authorizes private companies to charge a fee for the use of the credit cards, and as I think Judge Ray pointed out, that fee, of course, has to include a profit or nobody would do it. And the whole purpose of this statute is to encourage that it be done. And the third thing that it does is it permits the state agency to pass on, without any additional costs, the charge that they paid for it. That's what's happening here. The purpose of this statute, and by the way, one thing that it does not do, and no statute does, is prohibit a public officer from having an interest in a private entity unless there's something in particular about that that's prohibited by law, which this is not. But here's what the statute does do. It prohibits a double surcharge. It prohibits the consumer from being surcharged by the processor and then an additional charge being charged by the clerk or whatever the agency is. That's what it prohibits.
But Mr. Richard, counsel, if the association contracted with Visa, and I'm sure there are processing companies that are not using the credit card name, but with a processor, and the processor says, we will have to charge 3% for our shareholders and, for our company. That's the minimum, or 4%. I've paid 4% in private entities to use my credit card. So I know that 3.5% is not on its face improper. But if the processing company says, we're going to charge you 4%, let's say, and the clerks, the association, the clerks are allowed to pass on that 4%. But if the processor said, I tell you what, we can charge 4.5%, and we'll give that extra 0.5% to you. We'll call it a dividend. We'll send it to the association, and the association can use it to provide public affairs, governmental representation, continuing education. Would that be a violation of statute?
Well, you're asking a question that's not really relevant to the evidence in this case, and so I'd be giving you a declaratory judgment here. But my personal opinion is that in itself, it would not violate this statute, which says nothing about that. Whether it violated something else, I would need to do some additional research.
No,
but
that's
I do
all right.
not think that would violate the statute. The point here, though, is that never happened here. The point here is that what the Clerks Association was charging through Civitec was the lowest amount charged by any private company to any of the clerks, and nothing was added by any clerk anywhere in Florida. At least there's no evidence.
But did Civitec send dividends to the association?
Yes, well, the association...
Some of which amounted to millions of dollars annually, right?
That's correct, Your Honor.
Right.
And I think it's useful to understand what the evidence suggests the reason for this was. At some point, the clerk said, why should we be paying this money to private companies to go into the pockets of the private companies when we could be using the money to provide services, particularly to the smaller counties that can't afford it? Because here's what the clerks do with this. This is what the evidence said. They use the money to train clerks in smaller counties that can't afford to have training provisions. They use it for a geek squad type of provision where they actually go out to the smaller counties who can't afford to have an IT program of their own to provide them what they need in order to maintain the systems that they have. And they use it as a rainy day fund so that if our system ever goes down, they can keep the filing system going, which today is all electronic. Not $1 of this money is used for the clerk, the individual clerks privately. If the circuit judge found that if this were not available, the taxpayers would have to make it up, or we wouldn't have these services.
But I think that's the argument, right, is that under the statute, these are all totally legitimate purposes. I don't think anybody's arguing to the contrary there. Or I don't see the appellant arguing to the contrary, even though they use the term the fruits of their labors. Assuming they're all legitimate, which I certainly do. The argument is the statute prohibits the use of that as a revenue stream. The clerks are obviously quite at liberty to obtain general revenue or fees appropriated and approved by the legislature, but the statute says you cannot do it by by obtaining a profit from processing a credit card.
Well, that's what counsel is arguing. But I don't read anything in the statute that says that.
Well, counsel, let me draw your attention to subsection 5. And again, perhaps you can help me clarify the significance of difference in language in 5 versus earlier in the statute. But it caps the amount that can be surcharged for the credit card convenience fee to an amount sufficient to pay the service fee charges by the financial institution, vending service company, or credit card company. And that's it. So is the FACC processing company one of those entities? Is there room there for a private company to get involved and even have a profit margin?
Well, the evidence was that you cannot have credit cards without what they call the processor, because what the processor does, and I'm just talking about what's in the evidence, I never knew any of this before I got on this case. The processor facilitates the charge itself, the transfer of money from the credit card company to the agency, and then in cases such as child support, from the agency to the person, the parent who receives it. So that's why you have a processor. And from what I learned in this case, you need to have the processor. What this statute says, as I read it, is that whatever it is that is charged, you can only do it one time. Whoever it is, whether it's the credit card company directly, whether it's the processor acting as an agent for the credit card company, you get one charge. And the agency, and this is what I think is the key to the statute, the agency, clerks, Department of Revenue, whoever else it is, cannot add anything to that. All they
Right,
can do is
and
pass
that
it on.
matches the language of subsection 3, right, which says the total amount of such convenient fees may not exceed the total cost to the state agency. But that language is different than what we see in subsection 5. And maybe it's a distinction without a difference, but I'm struggling to put meaning, as I'm required to do, into the words, the limitations of financial institutions, vending service company, or credit card company. And maybe at the end of the day, it doesn't make sense under the way these things really operate, but that's kind of what we're wedded with.
Well, I suspect, Your Honor, that it doesn't surprise you that the legislature has written a statute that's not entirely consistent in its language, something that we need judges for. But I would suggest that what we go to, if we consider this an ambiguity, is what the legislative intent is. And the legislative intent is stated at the very beginning of the statute. It is to make available to the consumers of Florida the use of credit cards to pay their charges to state agencies, and it encourages credit card companies to provide that service. They're not going to provide that service if somebody can't make a profit from it, and from the evidence, they can't provide the service without these processors to assist
Well,
them.
let's try it this way, just for the sake of moving the argument along. And although I've granted you 5 additional minutes, I know you know as an experienced counselor you're not required to use it, so don't feel the pressure there. But let's assume, for the sake of argument, that the logistics of this violate state statute. That even though this is a private company, that it's formed solely for the purpose of benefiting the clerks. There's obviously a profit because it's paying dividends to the association. And I know you're not conceding that. I'm not asking you to. But assume that we determine that's the case. The argument here is, from your position as I understand it, that doesn't matter. Because there is no private cause of action under the statute, which there certainly is no express private cause of action, the declaratory judgment action cannot be utilized to essentially provide an advisory opinion. So even if we were to determine that the mechanism here violates the state statute, there's no remedy under the declaratory judgment action. That's part of your argument, right?
That's a very significant part of our
Right.
argument, yes, sir.
Could you embellish on that a little bit?
Yes. You know, counsel, in their initial brief, articulated this argument that it was a declaratory judgment action. We pointed out in our answer brief that there were multiple cases holding that there was no private right of action in cases for declaratory judgments, one of which was QBE, a case that they rely heavily upon. That was a declaratory action case. There is nothing in any of the long case law that we've had since the Sincar case, the case which changed the way that we approach this. As the court knows, originally, what the Supreme Court has said was you can file a private action if you are within the class of people that the statute is intended to protect or to benefit. They changed that, and they changed it in 1991, I think it was, in which the court said, no, it's entirely legislative intent. And if you can't read the legislative intent on the face of the statute, then you look to see if there's legislative history. Well, the fact is, in the 30 years since that decision, the court in every case has just looked at the language of the statute, and they have never articulated an exception because of declaratory judgment action. In matter of fact, the court has recognized no exceptions to that rule, and I think that we can probably consider what the likely reason is for that, because they did not want to encourage this type of a case where people would be filing class actions to challenge any statute that they found that might result in a large recovery, a significant portion of which would go to the named plaintiffs and go to the attorney's fees. They didn't want to encourage that. And if we start saying that you can file, that any private citizen can file a class action challenging any statute, even if the legislature didn't say so, we're opening the floodgates to these type of lawsuits.
What do you, I appreciate that, Counselor. What do you say in response to their argument that I'm not sure was particularly well laid out in the brief as far as the remedy goes, but hey, we want a declaratory judgment that this mechanism violates the credit card limitation fee. And, oh, by the way, we just want a supplemental remedy of, $50 million in class action damages.
And so what is it? What is it you're asking me?
I'm asking
I disagree with that.
I'm asking you but how do you read that language? And I'm sorry, I should have been more clear.
You mean the language in declaratory judgment?
Yes, the language in the statute that provides for supplemental relief.
Yeah, well, I don't think it contemplates a more specific statute like that, such as this one, and I don't think clearly you have to read it in paramateria with the rule on private right of action. And of course, first of all, anybody could defeat the private right of action by just including a declaratory judgment request, in which case you don't have any rule.
Well, so how would you read that then? For example, if a person's unclear about whether their contractual rights are breached, they file a declaratory judgment action, no question that it's not a runaround, that, you know, they have a legitimate declaratory judgment action. And therefore, the trial court can then determine the amount of the breach and award the damages. Is that permissible under that section?
Well, if I can answer that a little bit differently, this takes us back to what I recall was the very first question asked by this panel, which is why are you not asking for an advisory opinion?
Right.
Well, the reason this would be an advisory opinion is because there is no dispute as to an existing issue, because they have no right under this statute. They are actually asking for an advisory opinion here, because there is, and that's the point. You only get to use, you don't get the whole, we've gone to extraordinary, in all the years I've done this, I can't tell you how many opinions I've read where the courts are distinguishing between an advisory opinion and a declaratory judgment, and the distinction is always the same. You can't ask for it just because you'd like to know the answer. You have to have an existing, real, material controversy that you have to know the answer to know what you, the person asking, can do, not what somebody else can do. And that's what we're dealing with here.
So, counsel, so to Judge Thomas's question, if there was a breach of contract potentially, then, you know, the DEC action would be answering a question regarding a right that could impact the breach of contract, and that would be a separate count. And so in this case, if there were other counts remaining on the table, would your answer be different? In other words, could the DJA proceed because the right could be impacted with the other counts that were still remaining on for the court's consideration?
Thank you, Judge. And Your Honor, I'm sorry if I missed that was what
that's
you were
all right.
looking for. The answer is, I think the answer is yes, but that's only because if there are other counts, and assuming those other counts are based upon a real controversy that has to be resolved between the parties, then you can ask for declaratory relief as part of it. But you begin with the fact that there has to be something else, and what you're asking for is related to the two parties that are before the court. What these people are asking for is to tell us whether or not somebody else can do something. And I understand the way that they shoehorn themselves into that is by paying a filing fee or paying something else and saying, now we're part of the statute. But the point is that they didn't have the right. They have no rights under the statute to begin with. And so, and that goes to the substance of the argument, which I'm happy to address even further if you would like me to. But that's the problem. There is no controversy here based upon any statutory right that these parties have.
Well,
So
let me,
even, go ahead, I'm sorry.
well, I was just going to follow up real quickly. If we agree with you that these plaintiffs don't have standing, and I use that term loosely because it's really a judicial power question, who does? If there is, in fact, a violation of this statute occurring, what is the remedy and who has the authority to bring that suit or question?
Okay, let me go back for 1 second to follow up on something as that, and then I'll go right to that issue. The point is the declaratory judgment statute itself doesn't create rights.
Correct.
It doesn't create it. You don't have a right just because you're asking for declaratory judgment. Now, to go to the question that you asked me, in the first place, I think there are at least two public officials in the state who have the ability. One is the chief financial officer, who under this statute is made the officer that oversees it. The other is the attorney general, who, if somebody's violating a statute, can bring an action. But assuming that nobody has it, and there are statutes in which nobody or there is no penalty, doesn't make any difference. If the legislature says somebody can or can't do something and they provide no remedy and no statute, that doesn't suddenly make every private citizen in the state of Florida a private attorney general with the right to enforce it. Some statutes are statements of legislative desire, and they're not enforceable.
In other words, the legislature has a right to issue advisory opinions.
It certainly does. It certainly thinks it does. I was in the legislature once, and I probably voted for a few of those. So, Your Honor, I am happy to get into the details of the substantive question of the statute, but I frankly think the court has already covered covered most of it, so unless Your Honors have any additional questions, I have nothing more.
Thank
Thank
you,
you.
Counselor.
I have just a couple of points I would like to make. The first is with respect to what the industry standard is. Joe Stone, who is the CEO, not the
I
president.
think you can assume, for the sake of argument, at least for my purposes, that hypothetically, and again, I didn't ask Appellee's counsel to concede it, but assuming the court finds that the mechanism here violates the statute. The question is whether you have a remedy.
Right.
If you don't have a remedy, we don't have to determine whether or not there was a violation of the statute.
That's correct.
Although they're intertwined, certainly.
Right. It's a kind of a cart before the
Right,
horse thing.
right.
So your best argument is the supplemental remedy provision in Chapter 86.
Right, and I want to make a couple points that I think follow on or relate to that. The first is that, at least as I read the statute and the case law, you can have a valid declaratory judgment action without there being a private right of action under a statute. I think that they're separate things. Maybe in some ways they bleed through, but you don't, as I said, have to have that private right of action for us to, here in this case, be able to file a lawsuit against these entities saying that they violated the terms of the statute. We're not asking for an advisory opinion either. This is not something where there are no antagonistic interests, adverse interests, where there are no real-world consequences. So our clients paid money to pay the convenience fee, and they want that money back, the money that was charged in excess of the statute.
I don't think that's a question concerning, again, just speaking for myself, assume the statute was violated, assume that a citizen gets a $300 speeding ticket, pays a 3.5% processing fee, approximately $10 based on my loose math skill, and $3 of that $10 was profit to the Clerks Association. I think the argument from Appellee is your remedy is to possibly contact your legislator and take a look at the statute or contact the Attorney General and or the Chief Financial Officer, but that your clients, who nobody, at least Appellee perhaps has, but I certainly haven't argued, wasn't wronged by the excess fee that generated the dividends. But how is there a remedy under the Act? How can you gain through supplemental relief, as Appellee's counsel put it, how can you obtain through supplemental relief what you cannot obtain by the legislature's decision to decline to grant you a private cause of action?
Yes, sir. I understand the question, and for that, I'm going to refer the court to one of the cases we cited, which is City of Miami versus Fraternal Order of Police. It's a 1990 case from the 3rd District, and at least as I read the opinion there was no separate cause of action that depended on a declaration from the court. It was a dispute between a city and a health trust. The city denied a police officer's workers' compensation claim. Right. So it picked it up. And there the court said, even though it disagreed on the merits, which is the interpretation of the statute, it said, well, yeah, the trial court still had jurisdiction under the Declaratory Judgment Act.
Well, how then and that's the 3rd DCA, and I certainly respect that view, but we have articulated our view in several cases, including McNeil versus Crestview, which is a 2020 decision where we affirmed the trial court's dismissal of a DEC action for the sole reason that there was not a private cause of action that originated in that case under the PIP statute. Can you distinguish that case from the case here?
Yes, I think McNeil is distinguishable because, and this is from what I can tell from the opinion, the Four Corners, there it seems like the plaintiff was only seeking a determination on the reasonableness of the hospital's charges as well as their legality under the PIP statute. And I'm quoting in part from page 842. And it doesn't seem like the plaintiff in that case made any kind of claim for supplemental relief. In fact, I think in that opinion, there was, yes, a note at the top of page 844. McNeil contends that he is entitled to a declaration on these matters because of the existence of unspecified potentially available civil remedies for the hospital's violation of the statute. So he wasn't apparently claiming that under a declaratory judgment there was supplemental relief he could get. He wasn't claiming that some other cause of action depended upon the declaration.
I'll allow you to very briefly conclude.
Thank you. That's why I think that case is distinguishable, and for all of the reasons, including those in our brief, I ask the court to reverse this summary final judgment.
Thank you.
Thank you.
The court is in recess.
All rise.